Good morning, you're Miss Larry Fitzgerald Williams.
Yeah.
And this is cause number 25 DCCR 0985 and 24 DCCR 1790. And where are we on this? What is the announcement?
Well, Your Honor, we would like to, with some pre-trial publicity that this case had last week, along with some pre-trial publicity early on in the case, we're gonna be putting together a motion to change the venue. And I need about we want to have a hearing, and I just discussed this with the ADA about having a hearing in about 3 or 4 weeks on a motion to change the venue.
Okay,
Because they had a thing with Abbott last week that I think negatively impacted Mr. Williams in his case, and that we need to put together this motion to change venue because of the severity of this charge.
so I will I'll just do a normal reset, which
Yes.
is about 30 days.
Yes, ma'am.
If you'll get that filed, once that's filed, I would anticipate how long for that hearing to take place? How many, you would have a couple of witnesses, I would
Yeah,
assume?
yes, ma'am.
Mr. Smith
I think it could be done in a morning too.
in an hour or so in the morning.
Yes, ma'am.
So what we'll do is set it, well, it's gonna be set at normal time until we get that motion.
Yes, ma'am.
Once the motion, we'll keep it on that day and let's just
Okay.
make it at 11 o'clock on that day. But, and that way I need to make sure, or I need you to make sure and get that motion
It'll be done.
filed, and that way we'll do it at 11 o'clock on
Yes,
the
ma'am.
next court date.
Yes, ma'am.
Okay?
Yeah,
Yes.
in reference to my case, I filed a motion for discovery. It's been partially satisfied, but the medical records, if you go on the discovery page, have not been scanned. And what I want to do is file a motion specifically for the medical records to be given to me as a PDF file, not a TIFF file. Sometimes they do.
Can you, why don't you get with Mr. Smith? If Mr. Smith refuses to do that, then let me know and I'll get involved. But if y'all talk, I'm sure if you also could probably get a thumb drive and they can download it that way, I'm sure they'll accommodate whatever you need. But get with Mr. Smith if for some reason there's some things that you think you're not getting that you've talked to him about, let me know and we'll take care of that at
And
your
will I be required, in the 30 days reset for him, I'll make that the same appearance.
I mean, if you're going to join in that motion, I mean, we're not
But I'm
gonna, I
not,
would,
that's a separate case, so I'm not gonna.
Yeah.
do that motion.
I think it would primarily be with regard to the capital murder case and
So-
not yours. So I would think, let's see, we'll go forward. I would assume Mr. Smith is going to want to go forward with the capital murder first.
Absolutely.
Okay,
So,
well, I'd rather, if we need them both here, I don't want them to have to transport defendant twice.
Right.
But for the next hearing, if that motion's filed,
Yeah.
the primary purpose of that motion will be for the change of
Yes.
venue, and you won't be it won't be necessary for you to be here.
and so,
We'll give you notice of it. But if you just want to call and talk to Ms. Holmes and make sure what it's set for,
and they'll email me a new setting for him in reference to the 24 case.
I'm going to keep the cases together,
Yes,
just because that's easier.
okay,
I'm not gonna have Mr. Williams coming one day on transport
Right.
for Mr. Cash and one day for you. I'm gonna keep the cases together. For the next hearing, I'm telling you, you're gonna get a notice of it,
Right.
but you don't have to be here.
and then
We'll take care of Mr. Cash's motion, then we'll see where we get after that.
Okay.
Yeah.
Okay?
I'll send him a thumb drive.
Yeah, this is the first I've heard of an issue with the.
Well,
Okay.
I just.
Just, yeah, give them a call. Just, y'all work that out the best you can, outside of court. And if there's any issues, then let me know and we'll handle it here. Okay?
Thank you.
Thank you.
Thank you, Judge.
Yes, sir. Good morning, Ms. Burks. How are you?
Good, how are you?
Please raise your right hand. Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English? Thank you, ma'am. Good morning. Are you Heriberto Chavez?
Yes, ma'am. Señora Heriberto Chavez. Yes.
And this is 25 DCCR 0559. Mr. Chavez is charged with deadly conduct, discharging a firearm. And what is the announcement?
We are gonna ask for a reset, Judge. I'm kind of new to this case. He was
at the Jefferson County Jail and then moved to LaSalle, and we didn't realize it, so there was, anyways, got to meet with him, but need to go through the media.
Sure. Okay.
And Ms. Delay just approached me about changing my offer. I told her I don't see myself doing that on this case. So we'll just need to make sure she has all the discovery she needs so she can go with the client.
Okay. And so what I'll do, Mr. Chavez, is reset your case for about 30 days. And that'll give Ms. DeLage time to come visit with you over at LaSalle, go over all of the discovery that she's received, and we'll get a final decision on what do you want to do with your case at that next court date. Thank you. Thank you, Ms. DeLage. Thank you.
Thank you, Your Honor.
Thank you, Ms. Burge.
Yes, ma'am. Yes, ma'am. Thank you.
Ms. Burge, are you here on anything else?
Next door.
Okay,
Yes,
right. Thank you. I was gonna try to get you out of here if you needed something.
Yes, Stephanie.
Mr. Eckhart, you've got Alvin Wade.
After Mr. Eckhart pointed out certain impediments to our prosecution, I have decided to waive both of those enhancement paragraphs.
Okay. Thank you very much. Good morning, sir. Are you Alvin Wade?
Yes, ma'am.
And Mr. Eckhart, will your client waive the formal reading of the indictment?
We do, Judge.
Mr. Wade, in clause number 25, DCCR 1648, you, the state's elected to proceed on count one only. It alleges that you committed a third-degree felony offense of possession of a prohibited substance in a correctional facility. And that is from July 6th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Eckhart?
Yes, sir. Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? It just, I have to ask that to everyone. Are you a U.S. citizen?
Yeah.
Yeah, okay. State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Wade is not competent?
No, ma'am.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a prohibited substance in a correctional facility. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, so you did waive your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Allen. All right, good luck to you, sir. This is, yeah, this. Good morning. Are you Taylor Douglas?
Yes, ma'am.
Give me just a second. Good morning. Good morning. All right, will your client waive the formal reading of the motion?
He will, Your
I
Honor.
didn't already have that, sorry. This is cause number 25, DCCR 0895. And Mr. Douglas, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation November 18th of 2025 for the offense of obstruction or retaliation, a third-degree felony. And that was a 3-year deferred probation. Is that correct? And this motion alleges that you violated your probation in count 1 only by failing to act in a courteous and professional manner, by incurring 3 new incident reports while housed at the Jefferson County Jail, including a physical altercation with another inmate on November 29th, 2025, which was the same date of your last hearing. And so, is that true or not true?
True.
Did you enter your plea of true to count 1 freely and voluntarily?
Yes, ma'am.
And because it's actually true?
Yes.
So you never even made it.
I know. That's just, and I guess once you did that, you decided, screw it, I'm gonna do whatever I want because I already know I'm gonna get in trouble because you've been acting like an absolute fool in our jail. I'm not sure 4 years is enough. I need to think about this for a minute. I mean, is it really that hard to follow the rules?
No.
You didn't want to get out? You did? You got a problem with showing yourself while masturbating to the female officers out there, don't you? You don't?
No problem.
You don't have a problem? You just like to do it and you think that's cool to do that in front of them? Even though you know you're gonna get written up and go to prison for that? Was that worth it?
No.
Have a seat in the jury box. I'm not sure that I'm gonna accept this agreement.
You still in conflict?
So we need to do the 1 year. Okay, are you Sally Pope? This is cause number 24 DCCR 21110. Ms. Pope is charged with assault on a public servant and was previously found not competent to stand trial. I'm going to take judicial notice of the court's file. Ms. Pope was sent to the John Dunn Behavioral Science Center for competency restoration. I've received the report from them dated February 4th of 2026. It looks like we've got the trial competency evaluation report, which was done by a Leah Emery, Dr. Leah Emery and Dr. Samantha Guzman. That's dated January 29th of 2026. And finding is that Ms. Pope is still not competent to stand trial and unlikely to be restored within the time frame of the 120 days that she had there at the John Dunn Behavioral Science Center, and that further inpatient treatment would be warranted. In addition, I have a forensic psychiatry report prepared again January 29th of 2026. This is from Dr. Selek, Selek, also with the finding that Ms. Pope is not competent to stand trial at the present time. Also, a physician's certificate of medical examination for mental illness prepared by Dr. Selek. And the finding in that is that okay, so his finding is that she is not competent to stand trial, that outpatient treatment would be warranted is what his position is, and that the patient's condition is expected to continue for more than 90 days. That Ms. Pope suffers from mental illness that is severe and persistent, that a result of that she needs treatment. And then I have a second physician certificate of medical examination for mental illness. This is from a Dr. Nubia Luberis. And the finding in this report is also that Ms. Pope is not competent to stand trial, that she is mentally ill and this finding is also that she meets the criteria for outpatient treatment. And so, is there anything else with regard to competency from the state,
Not from the state, Judge.
Mr. Rojas?
There you are.
So obviously, just for the record, everyone knows that we do not have an outpatient competency restoration program here in Jefferson County. And so I have no choice but to find that Ms. Pope is still not competent to stand trial. Find while the recommendation is outpatient treatment, because we do not have an outpatient treatment program for competency restoration, I'm going to order the 1 year civil commitment for Ms. Pope to the appropriate facility. Obviously, if competency restoration is attained before then, we'll get her back here. Otherwise, we'll await the report from whatever facility she goes to. All right, so we're gonna try to get you some more help so that we can go forward with your
I
case.
go to Slidell in Louisiana.
I'm not sure where they'll, it's not up to me where they send you, it's wherever the best place is, okay? Okay, you can go back with the bailiff. Then Mr. Rojas, you've got Kaisha White now. No, because he's gonna need it. I don't need to make all that. He's gonna be, so he's if it's actually picking text, he's like, so. Yeah, let's, just reset. It's just one, right? We're gonna reset Brenda Sanchez for Mr. Kimler. He's in trial over in drug court. He will be here at 1, Mr. Nichols, for our hearing. But we're gonna reset his morning, and I think it's just Ms. Sanchez.
Yes.
Okay. All right, are you Kaisha White?
Yes.
And this is 24 DCCR 2063. Ms. White is charged with assault on a peace officer. Mr. Rojas, what is the announcement?
Judge, we're actually here for a competency review, competency hearing this morning.
Oh, I'm sorry. Let me do
And
that.
then
Okay, let me take
also-
judicial notice. Let's do that. Or go ahead.
She's also, she
We've
pled
already played this case.
January 7th of 25. She didn't show up for sentencing.
Okay,
And then when she was brought into custody, she was sent for competency.
okay. So did I,
She's never been sentenced.
She's never been
Yes.
sentenced.
but did we get a PSI? or
We did.
anything?
We did. She just didn't show up for the punishment hearing.
What date is it?
January 7th was the plea. She was set for sentencing February 24th of 25.
Oh, why this would have been standing in.
You got working.
It's okay. So let's do this. All right, so let me do this first and take judicial notice of the court's file. And Ms. White was previously found not competent to stand trial.
No.
No,
This is
she was, sorry,
found competent.
got it. Okay. She was evaluated for competency to stand trial. I've received that report from Dr. Rapon dated January 24th of 2026. The finding in that report is that Ms. White is competent to stand trial. Is there any other evidence with regard to competency?
There you are.
Not from the state.
Then at this time, based on that report, I will find that Ms. White is competent to stand trial. So have you spoken with Ms. White? Is it y'all's position to go forward with that?
I spoke with her about the PSI, about the previous plea, Your Honor, and she indicates to me this morning that she would like to go forward with probation. Is that right, Ms. White?
So when you were here last year, you entered a plea of guilty, and that was going to be with a deferred probation for 7 years was going to be the plea deal with a $500 fine and follow all of the rules and conditions of probation. So you've already done that plea. Do you want to go forward and get that probation today?
Yes.
Yes, I need. The problem is it's been so long, I don't have those. How can we find the plea papers? Oh, so it'll be from last year though, from January 7th of 2025, right?
Yes.
But probation doesn't have. Somewhere there should be an old PSI that has
And
their
that's what I
judgments, their orders.
And that's what I just want to
I
go.
believe it's on the side of that PSI I just gave you, didn't it?
But the actual order says.
Oh,
Yeah, we get other,
Oh,
okay. But if I do it today and we don't have those orders, is that something you can get with, to go back and get them to recreate? Because they've already been created. The date's obviously wrong, but they're somewhere. Somebody created them back then.
Yeah. Yeah.
The, on Mr. Smith's PSI, it just has that short, the supervision plan, not the orders. So when we're done, he can get you a copy of that also to see what they had done at least back then. It just doesn't have all of the orders that you guys attached.
Oh. Okay, send it to you.
Thank you. They're almost exactly a year from the sentencing date. Okay, so any reason then not to go forward with sentencing? Do we need any type of updated pre-sentence report, or you guys think we can get it done?
I think we can do it today, Judge.
No evidence that either of you know of any arrests since last year? Who's arrested if we know? You were arrested in November before Christmas? You remember when you were? Yes. Do you remember when you were arrested?
Yes.
Were you in jail for Christmas?
Mhm. All right, so what I'm going to do, Ms. White, I'm going to find that you previously entered your plea of guilty freely and voluntarily. I'm going to again find, based on Dr. Crapon's report, that you're competent and understand the nature and the consequences of that previous plea. I'm going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 7 years. You are ordered to pay the $500 fine and to follow all of the rules and conditions of probation. That will include being on a special mental health caseload so that you can get whatever help you need in order to understand what's going on and be successful with probation, okay? Do you understand?
Could you elaborate, Johanna?
Yeah, so tell me what you think and what you understand about the probation that you're gonna get. Do you have a question about that specifically? So what's gonna happen today is if I go forward and you get out of jail today, probation's gonna give you some paperwork today. And you need to go straight to the probation office when you get out of jail. Do you understand that?
Yes.
Okay, when you get there, they're going to go over all of the rules and the conditions and everything that you need to do so that you don't end up back here in custody because you didn't follow a rule. Does that make sense? Because what happens is if you follow all of the rules that you're supposed to on probation, You go to whatever classes they tell you to go to, you get any counseling, treatment, whatever it is. If you do all of those things, then you will not have to go to prison. You'll be able to, this case will be over when the time frame is over, and you won't have this conviction on your record. Do you understand that?
Yes.
If you don't follow all of the rules and you don't show up maybe for an appointment, or you test positive for drugs, or whatever the rule is, if you break the rule with probation, you can be brought back here in court. You could be found guilty of the offense, and I could send you to prison for anywhere in the range of punishment, which is between 2 years and up to 20 years in prison. Do you understand that?
I understand.
Okay. And so, I'm going to hand you the trial court certification that shows this was an agreement and I followed it, so you can't change your mind later and appeal. And again, so probation will talk to you before you leave today, but Ms. White, it's very important. Ms. White, it's very important that as soon as you're released from jail, you go to the probation department so that you can get started on probation, okay? So either today when you get out or first thing tomorrow morning, if you get out late, you have to go to the probation department. If you don't go, you're going to get arrested again and be back in court. Do you understand that? Okay. All right. Good luck. Thank you, Mr. Rojas. Thank you, Mr. Smith. And Mr. Smith, if you'll let probation look at that, please. I need the certification. Kaylin Douglas. Yeah. Kaylin Douglas. It should have been with, oh, never mind. Did I print it? Nope, I haven't yet. I kept it. That's why. Okay. All right. So just for the record, and I've gone back to review the pre-sentence report just to remind myself of what was in that and kind of what got us where we are now. And Mr. Douglas, I hate this because I really, really, really wanted you to succeed. I really did. I wanted you to be able to go to ISF, but I can't not stick to my word. I told probation when you were here, I told you when you were here, no more incident reports before ISF or you're not even going to make it. And it has been 1, 2, 3, 4, 6, 7. What day were we here? Dozens, at least. The sentence date was supposed to be, oh, look, sentence date was November 18th. So since November 18th. You've been caught with a, looks like kind of a makeshift tattoo needle. We've got 1, 2, 3. Four or 5 at least times when you have been exposing yourself while masturbating to the officers, spraying other inmates with disinfectant spray, horse playing, smoking. I mean, it's just,
Judge, I certainly understand your thoughts about it not being enough time, especially with the incident reports you're having a problem with on all these people in the jail.
no, I think I'm gonna go along with what you guys have agreed to. I just wanted some time to look at it. That I'm just reminding myself of all, I mean, the fact that you got this in the first place, because we went through, I have it all marked off on this PSI, your juvenile history and the opportunity you were given now that you're an adult to change your life and just follow simple rules. So, I am going to, let's see. So I have, documents here on this tablet that have your signature on them, that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
Do you understand if I go along with this agreement that you're waiving any right to appeal?
Yes, ma'am.
State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Douglas is not competent?
No, Your Honor.
All right, Mr. Douglas, I'm going to find that you entered your plea of true to count one freely and voluntarily. Find that count true. Find sufficient evidence at this time to find you guilty. Okay, something wrong. Find you guilty of obstruction or retaliation, a third-degree felony. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. And so today, just Mr. Douglas, just because you got time today does not mean that you still can't do better and change your life. Better you act in prison, the sooner you're going to make parole. The sooner you do that, you can get out, hopefully follow the rules and have the best life you can. You get in TDC and act like you've been acting in our jail, you're going to end up doing the whole 4 years. But you're eligible for parole in less than 2. In about 1.5 years, you're eligible for parole. And that's going to be 100% up to you. And I can assure you, you're not going to get it if you keep acting like this. All right. You can go back with the bailiff.
Yeah.
Thank you. Good morning. Are you Khalil Bradley Harris?
Yes, ma'am.
And Mr. Bradley Harris is charged with unlawful possession of a firearm by a felon in cause number 25 DCCR 1334. And Mr. Lane, what is the announcement?
Your Honor, I came into the case late and went over discovery. I apologize to Ms. Malvino. I have a media request, but the main officer, Miss Champagne, does not have her body cam. As listed, she says she has her body cam. There's like 8 videos that stop. And it's a very important video because it shows some incidences, whether there's a suppression hearing and where the gun was found.
So do y'all
things like
have
that.
it, or is it?
Judge, I'm sorry, it was late yesterday when he brought
Oh,
that to
okay.
my attention. If it is not on the thumb drive included, my file didn't reflect a media request, so I'm glad at least he has.
Yes, I've had the
Majority of
discovery.
things. I will
Okay.
take a look at the thumb drive I have, and if it's not on there, I will reach out to her myself.
Okay, I'll just do a normal reset. Mr. Bradley Harris, that will give Mr. Lane time to get all of the discovery. He'll come out, I'm sure, and go over all of that with you, and we'll get an announcement at the next court date. All right, thank you. You can go back with the bailiff.
I think our assistant's operator. Thank you, ma'am.
And then we've got Heyman Brandon Jr., Mr. Lane.
Yes, ma'am.
Last name, Judge?
Brandon, Heyman Brandon. All right, you are Heyman Brandon Jr.
Yes, ma'am.
This is cause number 21-36605. Mr. Brandon is charged with the first-degree felony offense of murder. Looking back at the file, which I'll take judicial notice of, it looks like Mr. Brandon was previously found not competent to stand trial and then sent to the appropriate facility. That looks like the Terrell State Hospital. And let's see, so are we now? I have received a report dated January 20th of 2026 from that facility with the finding that Mr. Brandon is now currently competent to stand trial. That evaluation includes a evaluation report, trial competency evaluation report that was prepared by a Dr. Jasani. The finding in that is, again, that Mr. Brandon is competent to stand trial. And that he is able to move forward with his criminal proceedings at the present time. That was also signed off on by a Dr. Lampley as well. So I have both of those doctors saying that he was currently competent to stand trial. We got him back and we're here now. So what is the announcement?
Your Honor, what I did was, I kind of challenged that. I thought I was going to challenge that. So I sent Dr. Capon out because we were having a hard time communicating even when he got back to the jail 3 weeks ago or so. Dr. Capon went out, also corroborating the fact that he feels like he's also competent.
Okay.
So I reached out to Mr. Smith, who is still dealing with the family. I'm still dealing with him, which is going to take a little time. I have a insanity evaluation that's also being done by Dr. Capon. If we could have a somewhat of an extended announcement, then we could come back and be prepared. I'm literally asking possibly, Governor Smith, for possibly a bench trial. The things.
So
that-
let's do this. What I'll do then, based on that report, as well as the, your statement that Dr. Rapon is also going to, and I believe I do have a copy of Dr. Rapon's report. It was probably meant to be sent to you, but it was sent to the court.
I asked them to send you a courtesy
Okay.
copy so we could kind of see where I was thinking.
Any objection to me taking that into consideration with regard to competency as well?
There you are.
So I'm also going to take judicial notice then of the competency evaluation report prepared by Dr. Rapon. It's dated February 12th of 2026. Again, it has the finding that Mr. Brandon is competent to stand trial. Based on both of the reports from Vernon's as well as Dr. Rapon, I'm going to at this time find that Mr. Brandon is competent to stand trial. And what I'll do is I'll do about a 45-day reset to see where we get at that time. And then we will see if we can get an announcement at that point.
Yes, sir.
All right, you can go back with the bailiff, sir.
Tell her she can't do it investigation.
He's trying to get up on me now. I don't think Ms. Holmes is going to join in on that. I have a feeling. There you go. Good morning. Are you Jonah Johnson? This is 25 DCCR 1775. Mr. Johnson, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon. And that's from August 31st of 2025. And what that means, sir, is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes.
Can you check if there's any of his in that pile? I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 15-year term in prison. You have every right to reject that, have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plead guilty. And do you understand all of that? And do you want to reject that offer and have your case set for trial? All right, we'll get that done. Mr. Johnson, Ms. Holmes has been appointed to represent you, and she's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release her and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, so Ms. Holmes, you are released. Mr. Johnson, we will appoint someone today. They should be out to the jail very soon to begin preparation for trial. All right?
It's wrong.
And there's none. And just because I get on to everybody for having incident reports, thank you for not having any incident reports. I mean, right? I feel like I need to, seriously though, it can affect your case. It can affect how the DAs look at your case. It can affect how a jury looks at your case. Continue doing what you're doing in jail, following the rules, because that's only going to benefit you, okay? All right, you can go back with the bailiff. It just can't be negative, but gotta just do some positive.
Yeah.
Let's see, you've got Almeda Miles.
Yes. So we don't know what to do next.
Okay, well, let's just get her out here and we'll figure it out.